evening. For those of you who do not know me, my name is Larry Roberts. I have the distinct honor, I guess, or dishonor of being appointed to some of these matters by the Supreme Court. Before we get started, I did have a notice from the electronic media for their presence here. I assume that in the audience and balcony or the news media. Kimberly, nice to meet you. Appreciate your presence. If you gentlemen and ladies will let me know who you are and who you represent, I would appreciate it. So I'll know who's present here.
I'm Dennis L. Horn, and along with Shuler Payne sitting over here, PAYNE, who represent the Clarion Ledger newspaper in the North.
All right.
Bob Anderson, also Larry Baker, table with me here on behalf of the state of Mississippi and from the Attorney General's office.
Your Honor, Jim Wade, W-A-I-D-E, Robert.
Thank you, Jim. Is there anybody else, party-wise participant? I do want to just generally talk about what we're here for and some matters that I would like to ask the Attorney General about, as well as Mr. Wade, you, since y'all are present here. First is arraignments. I know we're here on the Clarion Ledger's motions to intervene and unseal documents, but where do we stand? I know an indictment was returned last week against two defendants here. Where are we stand as far as formal arraignments or waiving arraignment and picking an agreeable trial date?
We haven't really had any discussion about the waiver per se, Your Honor. I think both defendants have appeared and were released on recognizance bond.
Right.
And we're at the court's disposal regarding the date for arraignment. That's announced regarding the waiver.
Mr. Wade, can I ask you about that? It's a formality, but it is a necessary formality.
Yes, Your Honor, court please, we would waive, I suspect that Brad would,
All right, let me ask this. The co-defendant in this case, is he represented by counsel?
We got a notice just a little bit earlier today that Dale Banks and there's an appearance for Mr. Bryant.
He is not present here today, is he?
No.
Do y'all gentlemen have any possible imagination? You haven't had any discussions with Mr. Banks about arraignment or a trial date? As of right now, we have co-defendants. There's no severance presently.
Your Honor, court please, I haven't, but I did know Mr. Banks representing Mr. Brad working today, so I suspect that later we could call him. Your Honor wants to be here, or I could ask him to be waived on it, whichever Your Honor wants done.
While I got y'all here, I thought it would be an efficient way to deal with it instead of trying to arrange a whole different day to get an agreeable date. And I assume for trial and a waiver of arraignment, let's get the show on the road to an agreeable date and time. I don't know what's y'all's position, but I would assume it would be relatively expeditious in the next few months anyway for a trial date, unless there's something I don't know about. Can we discuss that then later? An arraignment and maybe even during a break, a waiver of arraignment form, Mr. Wade, for your signature and for your client's signature, and discuss an agreeable trial date.
Your Honor, court please, we'll try to get Mr. Brad and his counsel over here before March, so I think they can probably do that.
All right. Also file in the existing indictment is a motion from the AG to disqualify Mr. Wade for representation of Mr. Smith. I know that's not set, there's been no order setting a hearing on that, but as soon as we complete the matters that Mr. Horn has brought us here for, we could address those matters too if you have no objection to that.
Very well.
Right. Mr. Horn, you filed numerous, it took a deputy to carry all these documents in here for me to look at, but you filed a motion to intervene and a motion to unseal documents in numerous case numbers.
Yes,
You filed a supplement to that motion. I'll give you the floor to let you proceed.
thank you, sir. We also filed, on 29th of August, we also filed a motion for a copy of the docket sheets.
Correct.
It's a preliminary matter, Your Honor. May I approach again, Your Honor?
Yes, sir.
Your Honor, I'm going to offer, for identification purposes, the corrected order appointing you as special judge and order Judge Green entered on August 12th, unsealing certain files for your eyes only.
Thank you, sir.
As an initial matter, Your Honor, a comparison of the causes that were assigned to you by the Supreme Court with a comparison by the files that Judge Green ordered unsealed leaves 3 cases that were not assigned to you by the Supreme Court. 16-00026, 16-00120, and 16-9004. So, if I may question the court, does the court assume jurisdiction over those 3 cases?
You're asking me a question I don't know how to answer. As I read the order of appointment, there's no question that I've been appointed a number of docket cases from the Supreme Court that they identified in their order of appointment. However, there's language in that order that says, Honorable Larry Robert shall preside as special circuit judge for any and all matters, motions, or actions involving the grand jury and/or administrative duties of Robert Shuler Smith, Hinds County District Attorney, pending or subsequently filed. I don't answer your question, Mr. Horn. I know I got the cases that have the number on them. How much further my authority goes, I don't really know.
Yes, sir. And Exhibit 1, which is the correct order appointing this special judge, about halfway down the first paragraph, there's language that says all circuit judges have recused of these subject actions. So, if Your Honor doesn't have jurisdiction, I assume I'll have to go back to Supreme Court and ask, see if they'll assign me the rest of this.
Well, let me ask you, we can eat the elephant at one piece at a time. That means go through the cases that there's no question about and deal with them individually is the only way I know, unless you have a better suggestion.
No, sir. As a matter of fact, I've spoken to counsel opposite Mr. Anderson, Mr. Wade, and we would all like to make announcements, but I can represent that we are all in agreement that all files assigned recordings, any documents in those files may be opened up and unsealed. That might cut through much of this.
Are we then talking about the case number that's been identified? I'll use the last 3 digits, 220.
Yes, sir. Yes, you've got a lot of paper. And for the record, Your Honor, no counsel, what I understand, speaking of counsel, officer, myself included, has any idea what these cases are, who the parties are. They're just completely sealed.
Let me address that for just a moment. I understand that the Clarion Ledger has standing to request that these documents be made public, even though the parties here agree that they should be made public. The court has some responsibility, in my judgment, to maintain the secrecy and integrity of certain grand jury proceedings, and by that I mean such things as identifying who may or may not be the target of the grand jury, who may or may not be a witness and expected to testify to specific types of facts to a grand jury, investigative type matters, and that's what's concerning me a little bit about what you're requesting.
May I address what you just said, Your Honor?
Yes.
I believe that once an indictment has been entered, the real need for grand jury secrecy is over. And I think Mr. Anderson would agree with that. He can speak to that, please.
All right.
Your Honor, our position is with regard to the matters that were, I can't unfortunately identify which case is which, because I did not participate in those. With respect to cases that were being investigated and were ultimately indicted by the Mississippi Attorney General's office, all of those cases have resulted in indictments, and the defendants involved have been served with the indictment. And as I read Rule 704 and 97-1153, I believe is the statute, once the indictment has been served upon the defendant, the grand jury secrecy concerns of the rule and the statute have been preserved as long as they should be. And we have no objection with regard. I think we're only talking about 2 defendants here that were the subject of inquiries and have now been indicted cases. It's been well publicized. The 2 individuals we're talking about, Christopher Butler and Darnell Turner. Both of whom have been indicted. They've had arraignments. They've been served with their indictments. I cannot speak, obviously, to the issue of whether one or more of these sealed cases involved an investigation or some inquiry by Mr. Smith, because obviously we did not have any involvement. Mr. Baker and I had no involvement in any investigation or grand jury subpoenas per se involving an investigation by the district attorney's office. So I can't speak directly to that issue. As to anything regarding Christopher Butler and Darnell Turner, I believe all of the requirements of grand jury secrecy have been preserved, and those 2 defendants have been indicted and served with their indictments at this point in time.
Okay, thank you. Let me go back to what has been identified as case number 25C 1116 CV 00220. That case number only. I do not know the status of that, but the original document that created that cause number was 2014. And I'm confident that Mr. Smith has knowledge of that document because it relates to the state auditors making an effort to prevent service of subpoenas on some of his apparent employees or attorneys. Is that matter still an active matter that may be presented to a future grand jury, or where? I mean, that's what case number 220 appears to be all about.
Yes, sir. I'm just waiting to respond to that. I don't know what any of these cases are.
Steve, I'm trying to figure out what we're talking about here.
All right.
While they're talking, Your Honor, may I present Your Honor later an order about Clarion Ledger to intervene?
Yes, sir, you may.
Thank you.
Here's what Mr. Smith tells me he believes that case is. I haven't seen it, it's hard for me to say what it is. What he says is that it's proceeding with the state auditor's office was attempting to force subpoenas on two individuals that have now been indicted. So there's an indictment already there. I may be mistaken because I can't see the papers.
All right, just one second. Can you name those individuals for me, sir?
Yes. Your Honor, Mr. Smith understands that concerns Huggins, H-U-G-G-I-N-S, and McDonald, both of whom have been indicted and served the indictments in the case of McKinney. That's what he understands that case.
And I understand neither Mr. Smith nor the AG's office has any objection to the Clarion Ledger request as far as case number 220 is concerned. Is that correct?
We have no objection.
Mr. Wade?
No, sir, Your Honor, Mr. Smith always filed this.
Okay. I'll order that case number unsealed. Make a comment to you too. Three sets of lawyers here. Having myself been a circuit judge for decades over in Meridian, from time to time matters occur in the circuit court arena that are neither a pending criminal case where there's been an indictment returned against an individual, nor are they a pending civil case. Let me give you a couple of examples. There's a statute that requires the senior circuit judge to establish terms of court for the coming year. An administrative order has to be entered by September 30th, unless they changed the law recently, September 30th of the preceding year, setting terms of court for the coming year. Sometimes you may have, for example, an intern who wants to be admitted to a limited practice of law, and he's otherwise or she's otherwise qualified, and the judge has to enter an administrative order authorizing that person to practice law in that court. I remember one time a request for a wiretap made by state officials before me for electronic wiretapping. And I took sworn testimony in chambers from the defiant to justify the issuance of a wiretap of a particular telephone. Obviously, those documents and that order have to be filed somewhere. So there's an administrative filing system set up by different judges, done different ways, as far as I know, all over the state of Mississippi, that give a number to to administrative action by the court. Hiring a court reporter is a good example, or a law clerk. They want to memorialize it with a court order appointment. And a lot of these materials I'm looking at appear to be that kind of thing. There's nowhere else to file it because there's no pending indictment and there's no pending civil action. And they're assigned a number. Now, the numbering system, admittedly, is extremely confusing to me, but in any event, that last case number, I'll unseal that, and Mr. Warren, if you would give, since it's your motion, responsible for submitting the order.
Yes, sir.
Let's go to your next one.
Looks like number 355.
All right, bear with me just a moment.
Yes, sir.
In a summary fashion, counsel, the document that originated the creation of case number 16355 appears to be a motion on behalf of the Attorney General's office to quash certain subpoenas. Apparently subpoenas appear before the grand jury for Christopher Butler and Mary Russian. Motion signed by Patrick Beasley. Attached to that motion copy of the grand jury subpoenas. And some other documents, including testimony of a preliminary hearing that took place in front of Judge Melvin Priester on March 3rd, 2016, involving Richard Butler, when he was represented by Attorney Sanford Knott. Also a transcript of some testimony before Circuit Judge Jeff Will on January 22nd, 2015, in pending indictments against Christopher Butler and Kwanzaa Hilliard, the hearing that took place in front of Judge Will. I think I can assume, correct if I'm wrong, those matters have either resulted in indictments or cases.
Yes, Your Honor, what you told us, as I appreciate what that involved, there were some older cases that were already indicted, 2012 cases already indicted related to Mr. Butler, and then the Attorney General brought some separate indictments in 2016. These particular subpoenas, I'm not absolutely certain that there was a time at which Mr. Butler's jail cell was searched in Hinds County, and that this may or may not relate to that search of his cells. Rushing is a jailer, as I understand, in Hinds County jail out of County. With respect to the Attorney General office, we had nothing further with respect to the relation to Christopher Butler. It's not already indicted.
And again, for the record, I assume Mr. Wade, your client has no objection to unsealing case number 355.
No, Your Honor. That's the purpose of the warrant sealed, unsealed, because we believe the transcripts contain scope for evidence and stuff like that.
All right.
I got the right transcript.
Ms. Hornfield presenting an order on unsealed case number 355. All right, let's go to case number
16-9002.
16-9002. Located, please.
Yes.
just a minute, I do not have that particular number case up here on my desk.
You want to go to the next one, Your Honor?
I assume that would be a good idea.
16-0-543.
I must say regrettably, I don't have that one in front of me, but from previous review late at night, that relates to, as I understand it, the petition to quash a subpoena to the grand jury that was filed by Mr. Sanford Knott. Counsel, I know I have read that somewhere, it's been a couple of weeks ago. So I can get that in front of me. My recollection is that related to, as I said earlier, a petition filed by Sanford Knott, who was ex-counsel for Chris Butler, requesting the court to quash a subpoena, that is a grand jury subpoena, for him to testify before the grand jury. His claim, as I recall, that primarily was attorney-client privilege. I don't imagine anything still remaining unresolved in that case.
Not that I know.
I think it was a grand jury subpoena, Mrs. Smith, that had served on Mr. Sanford Knott to have him appear before the grand jury, and Mr. Knott objected. I think there was an order. My recollection is Mrs. Smith should be privy to that. He was there. I assume the order was entered, that the order authorized Mr. Not to appear before the grand jury.
You know, I'm glad it's worth out, I don't know what order, for the reason Mr. Smith wants out, unseal, particularly, is because Mr. Knight, he was seeking to have Mr. Knight give some testimony concerning the alleged threats of his client, Mr. Butler. So it's in his interest, it's in Mr. Smith's interest to have that unsealed and get that transcript, assuming that's what it is. That's what he was seeking to get from Mr. Knight.
All right. Attorney General's office has no objection to the Clarion Ledger.
Not at all, Your Honor.
All right. I've ordered it unsealed also. And Mr. Cornish, you'll furnish an order.
Is that 9002?
That's case 16-0543.
543.
That's the one we were just talking about. Now, just a minute, I've been presented 16-9002. 16-9002 deals with a petition filed by the Attorney General's office on July 15th, 2016, signed by Larry G. Baker, Special Assistant Attorney General. Question that the court preclude the district attorney and his assistants from appearing before the grand jury and to call or recall the grand jury and to appoint the Attorney General's office as prosecutor pro tem to present matters to that grand jury. Obviously, I think the result of the Supreme Court actions, there is no order attached to this, but this particular filing number, but as a result of the Supreme Court actions and the order I entered for the calling of the grand jury last week, this is a moot point, I would think. All right. And Mr. Horner, unless I hear some objection by Mr. Smith's counsel, I'll authorize the unsealing of 16-9002.
Yes.
That concludes, I assume, all the unambiguous assignments that have been given to me.
Yes, sir. There's 3 cases that Judge Green called related, or she unsealed for you only to read.
And your motion to intervene and unseal deals with 16-00026.
Yes, sir.
TTG.
Yes, sir.
16-00120 TTG.
Yes, sir.
And 16-9004.
Yes, sir.
And that's the only 3 remaining
Yes, sir.
sealed. All right, just a minute.
Right away, you're looking at that after approval. I can't apply for a second.
Absolutely.
You're going to have to defer with the circuit court for a minute.
Excuse me, 16-00026. Mr. Attorney General, as I read this was initiated, that is the creation of this docket number was initiated by filing of a motion to quash subpoenas under seal on behalf of Honorable Jeff Will Sr., Patrick Beasley, Special Assistant Attorney General, Sean Clarion, Special Assistant Attorney General, Alicia Hall, Chief of Staff of the Mississippi Department of Corrections, Kevin Jackson, Director of Constituent Services of the Department of Corrections, and Lee McNeil, Criminal Investigator from the Office of the Attorney General. In that particular case, Mr. Smith is aware that Judge Green appointed a special master, Amy Whitten, to hear the matters and make a recommendation. Included in that docket number case appear to be a transcription of testimony and statements made by Mr. Beasley, Mr. Clarion, how do you pronounce his name? Clarion, Mr. Schneider, on behalf of the Attorney General's office. As well as some testimony presented in a hearing that occurred on January 11, 2016 in the Christopher Butler cases. And if memory serves me correctly, and it does, there's some testimony here in front of Honorable Amy Whitten, Special Master, about the necessity for these subpoenas and the subject matter that was under investigation at that time by the District Attorney's Office. Now, having said all that, I just think I remember Special Master Amy Whitten saying these matters will forever remain sealed. And there's some statement in here about at that particular time it was extraordinarily important that they remain sealed. What's the status of this matter now?
I'm familiar with that, Your Honor, in that I believe I attended that session with Mr. Snyder. There is nothing further pending, at least that I'm aware of, with regard to the matter that was discussed there. And we have no objection. In fact, we've never seen some of the testimony.
Testimony that Special Master Whitten, Amy Whitten, took was in the presence of Mr. Smith and maybe one of his assistants, and in the absence of the Attorney General's office.